So this week we're looking at the juvenile justice system. We're going to highlight the differences between the juvenile justice and the traditional system in criminal courts. So the juvenile justice system is the analog to the criminal justice system for youthful offenders. The idea is to help rehabilitate the juvenile offenders and get them back into functioning system. It's not a punishment system, just like our criminal justice system is. Juveniles are persons who have not yet achieved their 18th birthday. Juvenile court is a term for any court with original jurisdiction over juveniles. And then jurisdiction is the power of juvenile courts to hear cases involving individuals under the age of 18. Juvenile delinquency is the violation of a criminal law by a person who is under 18. Status offenders are those who commit crimes that would not be crimes if adults had committed them, say truancy or curfew violation. Divesting jurisdiction over status offenders and status offender institutions. In 1974, there was the Juvenile Justice and Delinquency Prevention Act that established a response to national concern about growing juvenile delinquency. Obviously, juvenile delinquency is to help make sure that they're in school and productive members of that specific institution. The established offenders would not be incarcerated in penal institutions, but try to get them back, again, rehabilitated and learning so that they can come out and be productive members of society. Neglected, unmanageable, abused, or other children in need of supervision are placed in the custody of these agencies at the discretion of juvenile judges. Generally, juvenile courts have broad discretion powers over individuals that are not yet 18. Parents. A medieval doctrine that permitted the state to take away the rights of natural parents and act as the parent of the child. Parentis pateri originated with the King of England. And again, it's the foundation of our system in terms of rehabilitation and not punishment. The modern applications range from dispositions. Normally, again, we're going to avoid confinement. It's going to be a last resort. We're going to work with the parents and the children to get them back in school. Do some sort of an informal probation so that individuals are watching over the children, whether it be a social worker or a juvenile probation officer, and making sure that they're functioning as productive members of that school. Juvenile courts are civil proceedings, so they're a lot less formal. They use different terminology. They don't normally keep a record, and usually they have less punishment options and more rehabilitative options. They're traditionally an American creation, and other courts use different types of reinforcement for juveniles, but it's not as delineated as ours. The first public reformatory for juveniles was done in New York, and it established in 1825 the Society for Prevention that housed these individuals relating to juveniles and provided them food, clothing, lodging, and it helped get the neglected and poor orphans off the street. And again, keep them consistent, keep them in school, try to save them and get them back in programs. It's kind of an offshoot to our foster care system and trying to get the individuals that maybe fell through the cracks back in and functioning. Truancy statutes passed in 1852, making school attendance mandatory and being able to be punished by fines for the parents or even potentially incarceration for the children. State homes were also used to help house these youth so that they could get into school. And many juvenile encounters with the juvenile justice system are prompted by referrals from police officers. They're not necessarily arrests, but they do require the court's attention in helping get the students back into school. These referrals can be made from parents, principals, teachers, neighbors, anyone that has direct contact with the youth. And then a petition is the legal document that's filed against the juvenile as a delinquent and helps establish what the court's going to be looking at. They then do an intake, just like we do in criminal adult courts. They do have a lot more discretion, however, so they can remand them into the custody of their parents. They can bring the parents in and do some sort of counseling. They can do alternative dispute resolution. And the figure in your book at 11.1 shows kind of how they petition. They can go off and do dismiss, probation, or another sanction, and how many petitions there are, and percentage-wise how that's broken down. There are prosecutors in the juvenile court. They have broad discretion again, and their goal is to get them rehabilitated and get them back into school. During the 1960s, and for the next 30 years after that, there were huge achievements made in juvenile courts. And again, getting a lot more programs, counseling, rehabilitation there for the youth. Kent v. U.S. waived to adult court without hearing, which his attorney demanded. The U.S. Supreme Court held that Kent's right to due process and to the effective assistance of counsel was violated because he was not given a formal hearing. And because of the Kent decision, waiver hearings are now considered critical stages and require an attorney for juvenile offenders. One of the most significant cases in juvenile court is In re Galt. They granted the following rights for juveniles: right to notice of charges, right to counsel, right to cross-examination and confrontation, as well as the right to invoke privileges against self-incrimination. Up until 1967, youths were not afforded those rights because they weren't 18. And then a year later, In re Winship established important precedents for juvenile courts relating to the standard of proof. It established a stronger proof needed in juvenile courts to beyond a reasonable doubt standard, which is what we're using obviously at the adult criminal level. And another year later, McIver v. Pennsylvania, the U.S. Supreme Court said that it is the juvenile court's judge's decision whether to grant jury trials to juveniles. And by 2005, only 12 states had mandated jury trials. Breed versus Jones raised the issue of double jeopardy, and they concluded that juveniles have been adjudicated as delinquents on specific charges. They may not be brought again. In 1984, we looked at the preventative detention of juveniles and whether or not it was constitutional. You have to look at whether or not the juvenile poses a threat to society or a risk to themselves or others, and those would be the legal standards to determine whether or not detention would be legal and constitutional for the individual. Today, 31 states, juveniles are not entitled to a trial by jury. In 9 states, they have the right to a jury trial. And in 11 other states, juveniles can be provided with a jury trial under special circumstances.